I am Dr. Harpreet Kaur from Army Institute of Law. My topic for the day is forensic investigation techniques and right against self-incrimination under Article 20 Clause 3 of the Indian Constitution and analysis. Introduction of the topic: forensic science and constitutional law intersect in the pursuit of justice, where the meticulous scrutiny of evidence meets the fundamental rights of the individuals. The realm of forensic investigation techniques is a testament to human ingenuity in unearthing trust hidden within the minutiae of crime scenes. These techniques, ranging from DNA profiling to digital forensics, serves as a pivotal tool in the hands of law enforcement to piece together the puzzle of criminal activities. Conversely, the right against self-incrimination enshrined in Article 20 Clause 3 of the Indian Constitution upholds the principle that no individual should be compelled to be a witness against themselves. This provision is a cornerstone of fair legal proceedings, ensuring that the power of the state does not encroach upon the personal liberties of its citizens. This analysis delves into the intricate dance between the advancements in forensic investigations and the inviolable rights guaranteed by the Constitution. It examines how modern forensic techniques can both bolster the search for truth and the challenges the protection afforded by Article 20 Clause 3, necessitating a careful balance between the pursuit of justice and the preservation of individual rights. As we navigate through this complex legal and scientific landscape, we uncover the harmonies and tensions that define the relationship between forensic science and the right against self-incrimination. Now, I will be discussing the forensic investigation techniques. Forensic science is a critical aspect of the criminal justice system. It uses scientific methods to assist in crime solving. Some key forensic investigation techniques are as follows. First is crime scene investigation. The first step in any forensic investigation is the crime scene investigation. This involves a careful and systematic search for physical evidence at the scene of a crime. The process begins with securing the crime scene to prevent contamination or loss of evidence. Investigators then document the scene through photographs, sketches and notes. They collect physical evidence such as fingerprints, blood stains, fibers and other trace evidence. This evidence is then preserved, packaged and sent to the laboratory for analysis. Crime scene investigation is a meticulous and systematic process that involves several key steps. First is securing the crime scene. The first step is to secure the crime scene to prevent contamination or loss of evidence. This includes ensuring there is no immediate threat to other responders and controlling the situation. Second is preliminary survey. Investigators conduct a preliminary survey to define and secure areas that may contain evidence. Third is documentation. The scene is documented through photographs, sketches and notes. This helps in creating a permanent record of the crime scene. Fourth is evidence collection. Investigators collect a wide variety of physical evidence that can be valuable for the investigation. This includes biological evidence, example blood, bloody fluids and hairs, latent print evidence, example fingerprints, palm prints, footprints, footwear and tire track evidence, trace evidence, example fibers, soil, vegetation and glass fragmentation, digital evidence, example cell phone, records, internet logs, email messages, tool and tool mark evidence, drug evidence and firearm evidence. Preservation and packaging of evidence. Collected evidence is preserved, packaged and sent to the laboratory for analysis. The type of packaging material used and the precautions taken depends upon the type of the evidence. Next is the analysis. The evidence is then analyzed in a laboratory by a forensic expert. The result of this analysis can help in identifying suspects and establishing reasonable ground for suspicion. The process of crime scene investigation requires a team of professionals, including case investigators and crime scene personnel, who work together to ensure that evidence isn't inadvertently damaged or destroyed. The team may consist of crime scene photographers and evidence collection personnel specializing in gathering specific evidence such as latent prints, DNA, trace evidence and the like. The goal of crime scene investigation is to identify documents and collect physical and biological evidence at the scene of crime with great care and a thoughtful approach, as the case under investigation has to be presented in the court. The success of solving the crime will depend on piecing together the evidence to form a picture of what happened at the crime scene. In case of Sanjeet Kumar Singh versus State of Chhattisgarh, this is a criminal appeal number 871 of 2021. The Supreme Court of India discussed the importance of proper evidence collection and handling procedure at the crime scene. The case highlighted the role of a station house officing in recording information, preparing the Mukhbir Suchna, forwarding the information to the higher officer, proceeding to the spot, stopping the car, serving a notice under section 50 of the Act, conducting a search and finding the contraband. For example, in case of the people of the state of California versus Orenthal Jam Simpson, case number BA097211, the connection and analysis of blood stain evidence played a crucial role. However, the case also highlighted the importance of proper evidence collection and handling procedures, as the defense argued that the evidence had been contaminated. This case, often referred to as the trial of the century, involved the former NFL player and the actor O.J. Simpson, who was tried and acquitted for the murder of his ex-wife Nicole Brown Simpson and her friend Ronald Goldman. Simpson's acquittal was a highly publicized event and remained a significant movement in the American legal history. DNA analysis. DNA analysis has revolutionized forensic investigations. It involves extracting DNA from biological evidence such as blood, semen, hair or skin cells, then analyzing it to create a DNA profile. This profile can be compared to the DNA profile of suspects or entered into a database to check for matches. Advancement in DNA technology have had a significant impact on criminal investigations. For instance, the development of polymerase chain reaction technology allows for analysis of very small amount of DNA. This has made it possible to obtain DNA profile from old or degraded sample that previously would have been unusable. The Supreme Court of India in Aparna Ajinkya Firodia versus Ajinkya Arun Firodia, this is appeal of 2023, discussed the role of DNA analysis in determining paternity. The court held that the required certificate under section 65 B subclause 4 is unnecessary if original document itself is produced. A notable case involving DNA analysis is State versus Gary Ridgway, also known as Green River Killer case. Ridgway was convicted of 49 murders based on DNA evidence, making it one of the first cases where DNA evidence was used to solve large number of related crimes. Toxicology and drug analysis. Forensic toxicology involves the detection and identification of drugs and poisons in the human body. This can be crucial in determining the cause of death or in cases involving drug facilitated crimes. For example, in the case of State versus Harold Shipman 2000, a British general practitioner, forensic toxicology was used to detect high levels of diamorphine in the bodies of his deceased patients. This evidence was crucial in convicting shipmen of 15 count of murder. In the case of State by Drugs Inspector Bengaluru Circle 3, Drug Control Department Bengaluru versus Mrs. Siren Drug and Pharmaceutical Private Limited, the Supreme Court of India discussed the role of forensic toxicology in determining the cause of death. The court highlighted the importance of forensic science laboratory report in the conviction of the appellant. Ballistic and firearm analysis. Ballistic is the science of projectiles and firearms. In forensic investigations, it involves the examination of bullets and firearm related evidence to establish link between a weapon and a crime. A famous case involving ballistic analysis is State versus Lee Harvey Oswald of 1963. The alleged assassin of President John F. Kennedy, the bullet fragment found in the presidential limousine were matched to Oswald's rifle. However, the accused was assassinated before the trial court come to the conclusion. In case of Sadaq Hussain versus State and City of Delhi, cases of 2019, Delhi, page number 723, the Supreme Court of India discussed the role of ballistic in criminal investigation. The court highlighted the importance of ballistic expert examination in cases involving the use of lethal weapon. Digital evidence examination. With the rise of technology and the internet, digital evidence has become increasingly important in forensic investigations. This involves the recovery and analysis of data from digital devices such as computers, smartphones and storage media. In case of G. Balaji versus Saravanswamy is of year 2019, the Supreme Court of India discussed the role of digital evidence in criminal investigations. The court held that the non-recovery of the digital evidence or failure to produce a report by a digital expert would not discredit the case of the prosecution, which has relied on the eyewitness. In case of United States of America versus Ross William Ulbricht, cases of 2017, this case involved several cyber and organized crime related offences by the creator of Silk Road, an online marketplace that sold illicit goods and service. Rose William, also known by the pseudonym Dread Pirate Robert, was convicted of charge including drug trafficking and conspiracy to commit money laundering. The case is significant for its discussion on the legality of surveillance technique and the admissibility of digital evidence in the court. Ulbricht was convicted of creating and operating the Silk Road, an online black market. Investigators were able to locate the Silk Road server and collect digital evidence, which was crucial in securing Ulbricht's conviction. In conclusion, forensic investigation techniques are essential tools in modern criminal investigation. They allow investigators to collect and analyze evidence in a scientific manner, helping to ensure that justice is served. Coming to right against self-incrimination. Legal frameworks. Article 20, Clause 3 of the Indian Constitution provides that no person accused of any offence will be compelled to be a witness against himself. The right, also known as right to silence, was adopted from the 5th Amendment of the US Constitution and was incorporated in our Constitution through the 44th Amendment. The Supreme Court has interpreted the word witness to include oral as well as documentary evidence. The case law on the topic is the Supreme Court of India in case of Nandini Satpathy versus P.L. Dani 1978, Supreme Court, page number 1025, held that protection of Article 20, Clause 3 arises at the preliminary stage of investigation. The facts of the case are: Nandini Satpathy, a former Chief Minister of Odisha, was accused of corruption. During the investigation, she was asked 132 questions and chose to answer none, invoking her right against self-incrimination. The Honorable Court extended the protection against self-incrimination to the accused during police interrogation, stating that the accused has a right to remain silent and not to answer any question that may incriminate them. Furthermore, in case of Venkataraman versus Union of India is of 1954, Supreme Court, page number 375, the Supreme Court established that this provision deals exclusively with judicial punishment. A leading case of Salvi and others versus State of Karnataka and another, AIR 2010, Supreme Court, page number 1974. This case is a significant ruling on the application of narco-analysis, polygraph test and beep in the context of Article 20, Clause 3 of the Indian Constitution. The fact of this case are, this case dealt with the validity of narco-analysis, polygraph test and beep, that is brain electrical activation profile test. The Supreme Court held that involuntary administration of such technique is a violation of right against self-incrimination, as it amounts to testimonial compulsion. In case of State of Bombay versus Kathi-Kalu-Ogad and another, AIR 1961, Supreme Court, page number 1808. In this case, the Supreme Court clarifies the scope of testimonial compulsion under Article 20, Clause 3. In this case, Kathi-Kalu-Ogad was accused of committing dacoity. The evidence against him included a confession and a handwriting sample. The court clarified that protection under Article 20, Clause 3 applies to testimonial acts that are likely to lead to incrimination by the personal knowledge of the accused. Obtaining thumb impression or a specimen signature does not violate this right. In case of MP Sharma and others versus Satish Chandra, District Magistrate Delhi and others, AIR 1954, Supreme Court, page number 300. This case was one of the earliest interpretation of Article 20, Clause 3. The case involved a search and seizure operation conducted on the property of Dalmia Group Company. The question was whether such a seizure violated the right against self-incrimination. The Supreme Court held that the provision of Article 20, Clause 3 does not apply to search and seizures. Therefore, document obtained during a search can be used as evidence even if they incriminate the person from whom they were seized. Next case is R.C. Mehta versus State of West Bengal, 1970, Supreme Court, page 940. The case involved the admissibility of evidence obtained through a blood test of the accused. The court in this case reiterated that the protection under Article 20, Clause 3 is against testimonial compulsion and it does not extend to material evidence obtained from the body of the accused such as blood samples. In case of Pool Pandey and others versus Superintendent Central Excise and others, the case involved the summoning of the persons for inquiry under the Customs Act. In this case, the Supreme Court observed that the right against self-incrimination is not intended to prevent the authorities from obtaining material evidence, but to protect the accused from being compelled to give testimony that could incriminate them. These cases collectively contribute to the legal framework that governs the intersection of forensic investigation techniques and the right against self-incrimination under Article 20, Clause 3 of the Constitution. They provide a nuanced understanding of how constitutional protection are balanced with the needs of criminal justice and forensic science. Now, coming to the procedural aspect, the Supreme Court has made it clear that in order to claim this immunity from being compelled to make a self-incriminating statement, it is necessary that a formal accusation must have been made against the person at the time of interrogation. Section 161 Clause 2 of CRPC 1973 also gives the right to the accused to remain silent. The procedural aspect of invoking this right during criminal proceedings are as follows. First is invocation. The right against self-incrimination can be invoked by an accused at any stage of criminal proceedings. The Supreme Court of India has clarified that for an individual to claim this immunity, a formal accusation must have been levelled against them at the time of interrogation. Scope. The term witness in this context has been interpreted broadly to include both oral and documentary evidence. Therefore, an accused cannot be compelled to provide any evidence, whether verbal or written, that could be self-incriminating. The limitations. This right is not absolute and does not extend to the compulsion of producing physical evidence. For instance, it does not bar the medical examination of the accused or the collection of thumb impressions or specimen signatures. Moreover, this protection is available only in criminal proceedings and not in civil cases or other legal proceedings. Testing and examination. Certain investigative procedures like narcoanalysis and DNA tests have raised questions regarding the right against self-incrimination. The Supreme Court has held that the compulsory administration of narcoanalysis amount to testimonial compulsion, thus triggering the protection under Article 20 Clause 3. Now, I will be discussing the international perspective. The right against self-incrimination is also recognized in other jurisdictions such as Fifth Amendment in United States, which provides similar protection against being compelled to be a witness against oneself in a criminal case. Now, limitations. While Article 20 Clause 3 provides a crucial right to accused, it also has certain limitations. First is applicability. The right is applicable only to the accused and not to the witness. Witnesses cannot refuse to appear or answer questions on the ground of self-incrimination, unlike in the United States where witnesses also enjoy this right. Nature of evidence. The right does not extend to the production of material evidence that may be incriminating. Physical objects or documents seized from the accused are not protected under this provision. Stage of proceedings. The right can be claimed only after a formal acquisition has been made. It cannot be claimed during general inquiries or investigation that may later lead to an acquisition. In conclusion, the right against self-incrimination under Article 20 Clause 3 of the Indian Constitution is a fundamental right that plays a vital role in maintaining the integrity of the criminal justice system. It ensures that accused are not subjected to undue pressure to confess guilt and that the burden of proof remains on the prosecution. However, the right is not without its limitation and must be understood within the context of its procedural aspect and a broader legal framework. Contemporary issues. Admissibility of narcoanalysis. Narcoanalysis involves the injection of a sedative drug to lower a person's inhibitions in the hope that they will freely share the information related to a crime. The Supreme Court of India has held that involuntary narcoanalysis violates Article 20 Clause 3 as it amounts to a testimonial compulsion. The revelation made during such tests are not admissible in court, although they can be used to guide further investigation. DNA tests. The DNA tests are generally admissible in the Indian legal system, especially in cases involving serious offences like rape or murder, due to their accuracy and efficiency. However, the Supreme Court has ruled that a DNA test cannot be ordered without adequate satisfaction regarding the need for this test, balancing the right against self-incrimination with the needs of justice. The debate on testimonial compulsion revolves around the tension between the need for evidence in criminal proceedings and the protection of individual rights. While Article 20 Clause 3 protects accused individuals from being compelled to testify against themselves, Section 132 of Evidence Act compels the witness to answer relevant questions, even if the answer might incriminate them. However, such compelled testimony cannot be used against the witness in any criminal case. Comparative analysis. The right against self-incrimination is a fundamental principle of justice that protects individual from being compelled to testify against themselves. This right is recognized globally, but its application varies from country to country. In India, the right against self-incrimination is enshrined in Article 20, Clause 3 of the Constitution, which states that no person accused of an offence shall be compelled to be a witness against themselves. The Supreme Court of India has interpreted this right broadly, extending it to both oral and documentary evidence, but not to physical evidence like blood samples or DNA. United States, the Fifth Amendment to the US Constitution provides the right against self-indiscrimination. They state that no person shall be compelled in any criminal case to be a witness against himself. This right is widely known as pleading the fifth and is a key component of the Miranda right informed to the accused during arrest. United Kingdom. In UK, the right against self-incrimination is not constitutionally enshrined, but is a common law principle. The Police and Criminal Evidence Act of 1984 and the Criminal Justice and Public Order Act of 1994 provides statutory protections. However, adverse inferences can be drawn from an accused's silence under certain conditions. Australia's right against self-incrimination is similar to that of UK, rooted in common law with statutory provisions in various legislation. The Australian High Court has held that this right is not absolute and can be limited by statute. In France, the right against self-incrimination is recognized under the European Convention on Human Rights, to which France is a signatory. The French Code of Criminal Procedure also provides protection against self-incrimination, emphasizing the right to remain silent. Europe, the European Convention on Human Rights, Article 6 protects the right to a fair trial, which includes the right not to incriminate oneself. This right is applicable across the member state of the Council of Europe. China's legal system does not explicitly recognize the right against self-incrimination. The Criminal Procedure Law of People's Republic of China provides some protections, but they are not as extensive as in democratic countries. Pakistan's constitution under Article 13 provides protection against self-incrimination. However, the application of this right can be inconsistent and there are instances where accused persons are compelled to give confession. Thus, while the right against self-incrimination is a recognized principle in many legal systems, its scope and application can vary significantly. In democratic countries, this right is generally a robust, with limitations being the exception rather than the rule. In contrast, in some countries the protection may be more formal than substantive, with actual practices deviating from the legal standard. Concluding the topic, in conclusion I can say that the interplay between forensic investigation technique and the right against self-incrimination under Article 20 Clause 3 of Indian Constitution presents a complex legal landscape. On one hand, forensic science has advanced significantly with modern technologies such as automated firearm identification and blood pattern analysis software, enhancing the accuracy and efficiency of criminal investigation. These scientific advancements have bolstered the ability of law enforcement agencies to solve crimes and bring perpetrators to justice. On the other hand, the constitutional safeguard provides by Article 20 Clause 3 ensures that individuals are protected from being compelled to incriminate themselves during legal proceeding. This protection is a fundamental aspect of the criminal justice system, reflecting the principle that it is better to let numerous guilty individuals go free than to convict a single innocent person. The right against self-incrimination upholds the presumption of innocence and ensures that the burden of proof lies with the prosecution. The challenge lies in balancing the need for effective forensic investigation with the individual's constitutional rights. While forensic techniques are invaluable tools for uncovering the truth, they must be employed in a manner that does not infringe upon the rights of the accused. The Indian judiciary has played a pivotal role in interpreting these rights and has set precedent to guide the law's enforcement and legal practitioners in maintaining this delicate balance. Ultimately, the goal is to create a just and equitable system where forensic science serves the cause of justice without compromising the constitutional rights of individual. As forensic technologies continue to evolve, so too must the legal framework that govern their use, ensuring that the pursuit of justice remains fair and respectful for fundamental human rights. Thank you and have a nice day.